Thank you all so much for coming out here on a Saturday. We really appreciate you being here. My name is Chanel Daniels, and I am the Symposium Editor for the New Mexico Law Review. And I would like to be the first to welcome you all to the 2023 New Mexico Civil Rights Act Symposium, its meaning and application. This is a really important event for the law school and for the law review and for the community, because this is the first in-person symposium we've been able to host in 6 years. So we are very excited to have you all joining us today. Just a couple of details before we get started. This event is being recorded and it will be posted on the UNM website. There's signs all over the area up front. They look like big stop signs that show you where the restrooms are. And for those of you who are registered for CLE attendance, just keep an eye out over the next couple of days for an email from me to certify your attendance here today. So without further ado, I would like to introduce Dean Camille Carey to provide our land acknowledgement.
Good morning. Welcome, everyone. Welcome to the UNM School of Law and the New Mexico Law Review Symposium on the New Mexico Civil Rights Act. I'm Camille Carey, Dean of the Law School, and I would like to welcome all of you this morning, especially our distinguished visitors and guests. I would like to now read our Indigenous Peoples Land and Territory Acknowledgement. Founded in 1889, the University of New Mexico sits on the traditional homelands of the Pueblo of Sandia. The original peoples of New Mexico, Pueblo, Navajo, and Apache, since time immemorial, have deep connections to the land and have made significant contributions to the broader community statewide. We honor the land itself and those who remain stewards of this land throughout the generations, and also acknowledge our committed relationship to Indigenous peoples. We gratefully recognize our history. We are very excited about today's symposium on the New Mexico Civil Rights Act. Thank you to Professor Joanna Schwartz, Julie Murray, and Matthew Segal for joining us here in New Mexico and for sharing your time and your talents with us. Thank you to Chanel Daniels, Sophia Bunch, and Aaron Sherratt, our law review students who organized this wonderful event. An extra special thank you to Chanel, who took the lead on this event. Thank you to Professor Carol Suzuki, our fantastic advisor to the New Mexico Law Review. And thank you to all of our speakers here today. We appreciate all of you for being here. This is a special legal community, and we appreciate your consistent and meaningful engagement with our law school and our students. We are thrilled to be offering this symposium on the New Mexico Civil Rights Act. We are proud of our state and its progressive approach to the development and enforcement of law. Thank you again for being here, and please enjoy this wonderful day that our students have worked so hard to plan and organize. Thank you.
Okay, so we will go ahead and get started with our event this morning. A little bit of background on the New Mexico Civil Rights Act. The New Mexico Civil Rights Act was passed in 2021. So due to the recency of the act being passed within the last, I guess it would be 2 years, there isn't a whole lot of published literature or published case law on this act that helps advise people of how to interpret it and how to apply it with their client work. And so our goal today is to set that baseline and get the discussion started about the New Mexico Civil Rights Act, and with the hopes that we can kind of motivate everybody to continue that discussion amongst their other legal communities in New Mexico. Along with this symposium, we are also publishing a special edition focused on the New Mexico Civil Rights Act. That will be coming out early summer, late spring of next year, and it'll be featuring at least 6 articles that are going to really focus specifically on the New Mexico Civil Rights Act. And so I want to thank all of our authors who are here with us today for putting in their time to help us with that project. So a little bit about how the day is going to go. We're going to start off with our morning session of being really broad, talking about the civil rights kind of claims that we have in New Mexico itself. and how you can use the New Mexico State Constitution to file claims. And then we're going to move into understanding the legislation behind the New Mexico Civil Rights Act. And then this afternoon, it'll be really specific, and you'll get to hear from actual practitioners who are currently bringing these claims and defending against these claims here in New Mexico. So without further ado, I'm going to go ahead and introduce our first two keynote speakers. We are joined today with Julie Murray and Matthew Segal. Both of them co-launched the National ACLU State Supreme Court Initiative earlier this year, and their practice with that group includes protecting and expanding civil rights and liberties through cases before various state courts. The types of cases that they do in this group really focus on freedom of speech, voting rights, persons who are accused of crimes, and other issues related to constitutional law. Prior to their work with the ACLU, their career experience really proves their expertise in this area, especially with Julie Murray and her litigation practice to challenge the restrictions on sexual and reproductive health and education, and Matthew Segal with litigating for the release of people from state prisons and jails during the COVID pandemic and temporarily halting President Trump's first travel ban. So please welcome Julie Murray and Matthew Segal providing their own points on the promise and perils of state civil rights acts.
Great. Well, good morning, everyone. This is such an amazing turnout for a Saturday. Congratulations and thank you to Chanel and all of her colleagues at the Law Review for putting on this event and for hosting us. I know Matt's going to speak in a bit, but I think I can speak for both of us that we are so pleased to be with you all and looking forward to conversations with you today about the New Mexico Civil Rights Act and the practices here. So I should say at the outset, Chanel said this would be very broad in the morning, and I'm going to underscore that because I am not a New Mexico attorney. I don't practice in New Mexico. What I really have to offer you this morning is a perspective of someone who has worked in states around the country, bringing novel state constitutional challenges, seeing what that constitutional litigation looks like in different states, including states without civil rights acts, like New Mexico has, and also having some ability to kind of look across states at what we are seeing nationally with respect to state constitutions and the enforcement of state civil rights and civil liberties. So, I guess in part, I will say, to give you a sense of this perspective, I will just do a brief moment on the origin story of the State Supreme Court Initiative. So the ACLU has an affiliate, a fabulous affiliate here in New Mexico, and has affiliates like that around the country with lawyers in every state. So it has this very unique position of being able to see and learn about different courts, different constitutional traditions, different trends in the law around the country. And I think that provides sort of a unique perspective and ability for us to litigate at the national level on issues that are important in state civil rights and civil liberties law. The impetus for this initiative, I think, on one hand, you could say state constitutional rights have always been important. ACLU affiliates and other advocates in the community have always been litigating in state courts or in federal courts asserting state constitutional rights in some cases. But what's different about this time, and I think what the impetus for this initiative and a lot of the work that is going on in progressive legal movement lawyering right now, is that at the federal level we have seen a dramatic retrenchment in certain individual civil rights and civil liberties. And looking ahead, at least in the near term, that trend does not seem likely to abate. So until I came to the ACLU, I was a litigator for Planned Parenthood, the national office, and was going around the country I always said our clients loved us and we just kept losing, but I appreciate the support. But you know, one of the things that we saw in that work was that state constitutions really mattered. There are some states where state Supreme Courts have recognized expansive rights to reproductive access, to reproductive freedom, and those states in many cases have provided key access points to abortion, both before the Dobbs decision, because access wasn't real for many people even before the overturning of Roe v. Wade, but certainly since that time as well. So Dobbs is one example, the retrenchment with respect to reproductive access, but there are other examples. The U.S. Supreme Court a few years ago issued a decision called Russo v. Common Cause that basically took the federal courts out of the business of looking at even the most egregious examples of partisan gerrymandering. You know, we have seen that with respect to criminal procedure protections, that kind of cutting back on the rights of individuals at the federal level. And the impact of this change in the federal courts, I think, has been even more pronounced because I will say I think many progressive lawyers, myself included, have come up in a tradition, a learning of law that really prioritizes federal rights and thinking about federal courts in a way that has contributed to the underdevelopment of state law in many instances. So you have generations now of public interest lawyers, plaintiff side lawyers, criminal defenders who have grown up learning about federal law far more than they do about state constitutional law. And that's how they've learned to practice. So changing that dynamic, I think, is also part of our project in terms of pushing for, throughout the life cycle of someone's legal development, to advocate for civil rights and civil liberties, this idea that people should be thinking not only about using federal law and federal courts as a tool, but not leaving state constitutional claims and defenses on the table. So the fallout of what I've described to you, I think, has been the underdevelopment of state constitutional law in many states. I mean, I can think of a state where I was litigating a couple of years ago that had a really unique constitutional provision since the late 1800s. And when you looked on Westlaw to try to find decisions applying or interpreting that provision, you could count them on one hand the number of state Supreme Court decisions that had ever cited it. So that is the challenge that I think advocates have with respect, and courts, candidly, with respect to interpreting and resolving constitutional claims that may not have been brought before and that may be brought more frequently under the Civil Rights Act here in New Mexico. And, you know, I think as we figure out how to approach those decisions, one of the things that is going to be required is a creativity and willingness to try new things from a new generation of attorneys. So for those of you who are students in the audience, thank you for being here, and I think you have a really important job ahead of you. I think one of the other indicators of the fallout of this approach of focusing on federal law to the detriment of state constitutional protections is that the resources also aren't there to the same extent with respect to how do you argue state constitutional claims. Where is the history, the constitutional history of particular provisions? You know, I know Matt and I had an experience talking with folks in another state once about a provision and the history of it, and we found out it had just been in paper form and in fact had accidentally been thrown away by a janitor during cleaning, and it's just, so there just is no history from this amendment to a constitution. So those are real world problems that I think are facing advocates doing this work and courts that are going to be faced with resolving these kinds of things. That said, I think we're having kind of a renaissance of state constitutional law and an increased focus on state constitutional law. The ACLU's initiative is one example of that, but it is just one. And so I think that is going to have a number of impacts around the country, but certainly here in New Mexico with the Civil Rights Act. New Mexico's adoption of the Civil Rights Act has occurred against this national backdrop that I've been describing, and I think it will serve as a powerful example for the vast majority of other states that do not have any equivalent to the Civil Rights Act or any analog to Section 1983 under federal law. I think as you'll hear further today, there's also good reason to believe that the Civil Rights Act will spur folks to go to state court where they might in the past have filed in federal court, or to bring state constitutional claims that in the past, or defenses that in the past they might not have raised. And I'll leave to others today, I think people will go into that in more depth as to why that is and where we are most likely to see those trends. But I would say at least kind of at the outset, I think that is a good thing that we're going to see these state constitutional claims in new ways and in new places. And it is especially a good thing in a place like New Mexico, which really has some unique and interesting provisions in its constitution. I will say, one of the, I don't know if it's, I can call it a hobby, or I will sort of out myself as one of those kinds of lawyers, but I've kind of taken up reading state constitutions whenever I, look at. So at this point, I just read through them, thumb through them. Usually the Declaration of Rights, but oftentimes we'll, skip around. The miscellaneous section often has really good stuff in it. But so I did this with your Constitution, and a few things jumped out. One is that you have a really broad free speech provision that looks very different from the federal First Amendment. It does, in fact, look very similar to some other state constitutions, which is really common. Oftentimes, state constitutions look more like one another than they do the federal Constitution. You have an Equal Rights Amendment, which most states do not have, that expressly prohibits discrimination on account of sex. You have a free and equal elections clause, which the federal Constitution doesn't have anything that has that kind of express guarantee. I could go on, but my point is there are some unique and interesting provisions in your Constitution that deserve full billing and really thoughtful consideration about what those provisions mean, how they should be applied, and how they should be applied going forward in novel contexts. So I think the Civil Rights Act is a really important step in the direction of encouraging these kinds of constitutional claims, encouraging people to bring them. But I want to focus the rest of my time this morning, and then I'll turn it over to my colleague Matt, on the other steps that I think are really important, especially in a state like New Mexico, where you are likely to see new constitutional claims being brought because of the existence of the Civil Rights Act and this clear way for people to vindicate their rights. So the first step that I want to focus on that I think is important for sort of lifting up state constitutional rights has to do with how and when courts interpret state constitutional provisions where a comparable federal provision exists. So New Mexico courts have applied what's called an interstitial approach, or an interstitial analysis. And this approach prioritizes federal law in a couple of ways. The first way is with respect to sequencing. So at least as I understand the New Mexico approach, and I think there are some other states that have used this, if someone brings a state and a federal claim, the state court will first decide the federal claim, and only if you lose under the federal claim or the federal defense will it then look to the state defense. So, one thing that kind of recommends this approach, right, is it's probably more straightforward. There's a heck of a lot of federal law that is either binding on courts or you could look to for persuasive value. So
So it is definitely more straightforward in many instances. But what it does is contributes to the development of federal law while leaving state constitutional claims and defenses to kind of languish in the background and come into play only if federal law does not provide relief to a plaintiff or a criminal defendant that they've requested. The interstitial approach prioritizes federal law in another, sort of a second way that I think is important. What happens where someone brings even if they don't bring a federal claim, if someone brings a state constitutional claim, what this approach does is starts with a presumption that if there is a federal constitutional provision analogous to that state constitutional claim or state constitutional provision, that the court will use federal doctrine or federal precedent unless a few exceptions apply, and one of those could be very different texts or very different traditions, but the presumption is that state courts will look to federal law when interpreting state provisions that are analogous to federal laws. So those are the two ways that the interstitial approach that New Mexico uses really does prioritize federal law, both in terms of deciding federal claims first if they're in the case, and in terms of using or importing federal law into state law where state and federal constitutional provisions are similar. I would say, just this last month, the New Mexico Supreme Court addressed the interstitial approach in an opinion that permitted a state constitutional challenge to congressional districts to go forward. And if you haven't read that opinion, I would recommend you do. It's interesting legally on a number of issues, but in the opinion, and I think for purposes this morning, what I want to emphasize, the court said the interstitial approach that we've used so far isn't required. This is a judicially created doctrine, and I'm quoting here, they said, "We encourage thoughtful and reasoned argument in the future, addressing whether the interstitial approach is the proper method to ensure the people of New Mexico the protections promised by their Constitution." I mean, I will say, that is pretty clear court speak to me anyway, and I hope every advocate in this room heeds this invitation to think about arguments with respect to the interstitial approach and whether it makes sense for your clients, for courts to continue to use that approach. My own view is that the interstitial approach, which has been, I would say, criticized by jurists and academics across the ideological spectrum, should be abandoned, and particularly now that the Civil Rights Act has been adopted here in New Mexico. And I'll give you a few reasons for that. The first is that by requiring courts to decide federal constitutional claims or defenses before turning to state ones, the interstitial approach leads to the unnecessary resolution of difficult federal constitutional questions, with potential national implications if the U.S. Supreme Court ultimately reviews those decisions. But that's not how the system is supposed to work. If state courts can decide a case and render full relief to a plaintiff or a criminal defendant on state law grounds, why wouldn't they take that narrower approach to resolving a case? Keep in mind, by way of comparison, in federal court, there's a doctrine called Pullman abstention that cautions courts against deciding hard federal constitutional questions of law where an independent state law ground exists to reach the same outcome. So the interstitial approach really turns that doctrine on its head. On one hand, you have federal courts that, where there is a state claim to avoid deciding a hard federal constitutional issue, they're looking for that. And then you have an interstitial approach that encourages state courts to first decide federal constitutional questions before they even look to state law claims. The second reason that I'd say the interstitial approach is so problematic
is that it presumes that federal constitutional interpretations of analogous provisions are correct, and that they should come into state law wherever possible. Again, that's not how our federal system works. State courts are the final arbiters of state laws in their own states, and provided that state laws and actions don't violate the federal constitution, states can decide to offer more, or in fact less, protection under their own state constitutions as a matter of state law. So state courts might ultimately find a U.S. Supreme Court interpretation persuasive, but there's no need as a matter of state law to prioritize those rationales over the jurisprudence of any other state, which may in fact have a constitution that looks much more like yours. And the third reason that the interstitial approach is so problematic, and that I think is something to keep in mind as you think about how the Civil Rights Act works in this state and how courts deciding Civil Rights Act claims are resolving constitutional questions, is that the approach encourages litigants and courts to start their interpretation of state law by falling back on federal instincts. You look first to what does the federal interpretation of this analogous provision say? And I think a better way of doing things is to tell litigants and for courts themselves to say, look, we start with the text, and we start with our text, not the U.S. Constitution's text, which may be very similar but not identical. So starting with first principles under state law as opposed to importing federal law, I think is a really important way of prioritizing the development of state constitutional law. So I've told you lots of reasons why I think the interstitial approach should be abandoned. You may be wondering at this point, well, what are you going to do instead? The good news is that there are examples of other states that have gone a different way, and they went a different way decades ago. So they have examples of how a different approach has worked. New Jersey, for example, has a primacy. New Jersey, Oregon has a lot of case law from the 1980s about a primacy approach. And under that approach, basically what happens is if you have a case where a plaintiff has a federal and a state claim, or a criminal defendant has a federal and state defense, the court's going to look first to the state constitution. And then, only then, if it needs to, will it look to the federal constitution. So, under the primacy approach, I think it does address many of the problems that I've identified with the interstitial analysis that is used in New Mexico and that has been criticized by a number of commentators. And I think it would likely lead to a more robust development of state constitutional law. So, at this point, you may be thinking, well, if we were going to do that, that sounds like a lot of work. It sounds like a lot of briefing. It would require sort of changing up the way that you brief claims and developing new arguments, potentially delving into history that folks have not been asked to delve into in the past. And if that's where your head is going, I guess what I would say is you might be right, at least in some cases, early on after the development or the adoption of a primacy approach. And I think the reality is that to end a reflexive adoption of federal law for state constitutional purposes, advocates are going to need resources. It means that briefing state constitutional issues in a more developed way is going to take more time. And it may involve delving into particular state constitutional provisions that there's just not a model for. And courts will need to play an important role in ensuring that they have the information they need to resolve these claims in a sensible way. It's also critical that the public have a clear and streamlined way to know about cases reaching the state's high court and have an opportunity to weigh in through amicus briefs. Those briefs can help courts reach better decisions and understand state constitutional provisions that may not have been interpreted frequently.
The good news here, again, is that there are good ideas from other states that folks might want to think about here in New Mexico. The New Jersey Supreme Court, for example, posts not only all of its decisions to grant review in a case online, but also the questions presented in those cases. So there's a very easy way, if you go to their website, you can see exactly what is pending in front of the court as soon as it's granted. And in fact, for amici, the deadline for filing a brief is pegged to that posting. You have 75 days to file an amicus brief after this public posting. So it really is a way to try to make it more transparent what is at stake in important constitutional and other cases that reach a state's high court. And I think something like that in New Mexico and other states could be really helpful as states have this resurgence or increased focus on state constitutional law. Another example that I'll give you is Michigan. They have a practice of when they grant cases to hear, including constitutional cases, actually directing the clerk to send invitations to various community groups, bar associations who might be interested in weighing in on the constitutional or other questions in those cases. So an employment case, you might have the State Employment Lawyers Association weighing in. You might have the ACLU weighing in a case involving rights of protesters. That kind of affirmative outreach, I think, ensures not only that the public is aware of what's happening in state courts, which is itself really important, but that state courts, as they are facing novel constitutional claims, really are bringing in as much information as possible that could be helpful to them in resolving those claims. I don't mean to suggest these as sort of one-size-fits-all approaches, only that they're useful practices, and that I think as we embark on this next round of focusing on state constitutional rights nationwide, that I think there's a lot of creativity that states and advocates can bring to bear to help that process along. I'm heartened by what New Mexico has done with its Civil Rights Act, and I think it could be a leader in numerous other ways to help to prioritize state constitutional rights and the development of law over them. So with that, I'm going to turn it over to my colleague Matt, who's going to speak for a bit, and then if we have time left over, we can do some questions.
Good morning. Hi, I'm Matt Segal. I am so grateful to be here and to see so many people here. This is amazing. Congratulations to Chanel and to all the other students who make this happen, and to the dean and all the faculty at the law school for doing this. This is outstanding. I will also say that as a lawyer, when you go to appear in court, the advice is you always have to make sure that you're the expert. You have to make sure that you know more than the court does. So it's a bit terrifying to stare into an audience where I'm pretty sure that literally every single person here is more expert than me on the subject that's on the screen. So I will do my best to give some thoughts about the New Mexico Civil Rights Act in light of what I've seen elsewhere. And here's where I'll start. I guess the thing about constitutional rights is that everyone agrees that they're important, but beyond that, nobody agrees on anything. If you ask 10 different people or 10 different lawyers, what is the most important right, you will get 10 different answers. If you ask people where are rights most in peril, again, you get 10 different answers. Or you might get the same answer, which is not here. There are problems, but in another state. There are problems, but in another town. And I guess for what it's worth, my answer to that question, based on things that I've seen in my work, is that constitutional rights are in peril whenever it costs nothing to violate them. And that's because if people understand correctly that they can violate someone's rights without consequence, that's what will happen. And my sense is that the New Mexico Civil Rights Act puts New Mexico on a path to making New Mexico a place where rights are respected, where rights are followed. As I understand it, it permits lawsuits based on violations of the rights, privileges, and immunities cured by the Bill of Rights of the Mexican Constitution. It protects a qualified immunity defense. It allows for attorney's fees, which means people who might not otherwise be able to afford lawyers, even in cases where their damages might not have been, their physical self might not have been harmed, but their dignity might have been harmed, they might be able to get lawyers in those cases. And that's really important. And so today I'll talk a little bit about what I think might be sort of an underappreciated aspect of the Act, and about the work that maybe remains to be done. So these observations are formed from my own experiences, representing people over the last 15 years who believe that their own rights have been violated. I've worked with people who sought to vindicate their rights through lawsuits. I work with people who have sought to vindicate their rights through motions to suppress evidence in criminal cases. And I work with people who, sadly, did not seek to vindicate their rights because they were in circumstances where there was no means for them to do so. And finally, I want to say I work collaboratively with people, with prosecutors and people in law enforcement, including as a member of a commission on qualified immunity in Massachusetts. So I hope I can see things from more than one perspective, although I suspect maybe that's not always true. And so based on those observations, I just have 30 or so slides that I want to go down. I just want to make 3 points. And the first is that, as Julie alluded to, the New Mexico Civil Rights Act appears to be enormously promising, not just because of the opportunity to litigate violations of rights, but because it figures to help with the development of state constitutional law in New Mexico. Second, based on what I've seen elsewhere, it's important to safeguard this act and to make sure that it is strengthened rather than weakened as it starts to be used in court. And the third thing is to understand that it is one tool. It can't be the only tool. No civil rights remedy, no matter how powerful, no matter how good, can perfectly protect civil rights and civil liberties. And so I want to emphasize, because there's so many of you in this room today who clearly care about getting things right, that the existence of this tool should not come to be an impediment to the creation of other tools. So on the first thing, debates about civil rights and civil liberties often cited the fact that the goal is to eliminate, not sue over violations of rights. So as a civil rights lawyer, it's never been my goal to get the most fees. I mean, if anything, my goal is to get to the point where I don't ever have to bring another case. And that's what we're all looking for. And the New Mexico Civil Rights Act seems to get us closer to that goal, not only because it will allow people to sue for violations of their rights and hopefully therefore to deter violations, but also because once these cases start to be brought, and I understand that some already have been, it will give courts the opportunity to say more about what those rights are. And that will be helpful not just to people whose rights are violated, but to government officials who presumably do not wish to violate people's rights and might do less of that if only someone would tell them more clearly what the rights are. So, as you heard from Julie, it's part of our work at the Civil Rights Initiative to understand what's going on at the State Supreme Court Initiative, to understand what's going on in other states and why some states in their courts, they follow lockstep with the U.S. Supreme Court's interpretation of federal law, and some don't. And sometimes the answer is very complicated. It can have to do with the text, the traditions, the values of a particular state. But sometimes the answer is not complicated. Sometimes the answer is just state constitutional law is less robust than it might otherwise be because the courts aren't getting the cases that would allow them to say more about what they understand their state constitution to say. And that's where I think the New Mexico Civil Rights Act is going to make, among many of the differences it will make, this will be a huge difference. Even in states where lawsuits are allowed, if the relevant Civil Rights Act has been interpreted to afford a qualified immunity defense, then the same problem will arise. Because, as a lot of you know, the U.S. Supreme Court has held that qualified immunity applies whenever the relevant right was not clearly established at the time of the incident. And the U.S. Supreme Court has also said that in that circumstance, a court applying the federal rules can grant qualified immunity without clarifying whether the right exists or it doesn't. And that means the right remains unclear, not only in that case, but the next one, and the one after that, and the one after that. And that lack of clarity leaves everyone in the dark. People who want their rights respected, and people who have the power to violate those rights. And this dynamic can both stunt and warp the development of state constitutional law. It can stunt the development of constitutional law because without a state civil rights act or with an act that allows a qualified immunity defense, some hugely important state question of state constitutional law just never get decided. And it can warp the development of state constitutional law because other important issues will be decided, but they will be decided maybe in criminal cases, in motions to suppress, for example, where the facts are quite favorable to the government, rather than in affirmative lawsuits where the facts might be less favorable to the government. Think of a situation in which there's a stop and frisk practice that gets to court only in the small number of cases in which the police find something. This is welcome to reign for the government. So consider what might happen under these various regimes in a situation where the police disperse a group of protesters for what the police feel is a good reason and for what the protesters feel is not. Now, as Julie just said, there is good reason to believe that the Constitution in New Mexico provides broader protection for free speech than the U.S. Constitution does. But if there's no Civil Rights Act, nobody gets to find out who is right in this scenario. Whether the police are right, that their reason was sufficient, or whether the protesters were right. And under that regime, or under a regime that has qualified immunity, not only is the law not clarified in that case, but it remains unclear at the next protest, and the one after that, and the one after that. And so hopefully, at least my hope is, with the New Mexico Civil Rights Act in place, that sort of problem will get solved. Or consider the case of a hypothetical civil rights plaintiff bringing a federal and state claims against alleging police brutality. For the federal claim, under a qualified immunity system, the federal court will have the option of just ducking the question if the court concludes that the relevant law is not clearly established. But if there is a claim as well under the New Mexico Civil Rights Act, the state court applying that claim will not have the option of ducking the issue. And will have to decide whether, in fact, the police used excessive force or they didn't. And maybe This is the goal. And maybe clarifying that issue, if the plaintiff is right, will help to prevent it from happening again, which is what we should want. Sometimes plaintiffs will win, sometimes they will not. As Julie alluded to in her plaintiff advocate days, as a civil rights lawyer, I know a thing or two about the not winning part. But unlike in systems where there is no Civil Rights Act, or where there's qualified immunity, the wins and losses will hinge on what the Constitution actually says, and not on the quirk of, for example, whether a similar case with the same facts has previously existed. And that should be good for the development of state constitutional law, but it should also be good for the people of New Mexico who depend on that law. Second thing, so in the civil rights world, nothing stays won. Even when you win, you have to keep winning. And this is very true of civil rights acts. I say this because other civil rights acts, other civil rights remedies have been weakened over time. And in Massachusetts, this was true. This was the place where I litigated for over a decade before joining the National Assembly. There is a Massachusetts Civil Rights Act, which, by the way, makes things confusing because now I have in my head NMCRA and MCRA, and it's a mess. But the MCRA, the Massachusetts Civil Rights Act, was enacted in 1979, and at first blush, it seems very broad. For example, a person can be liable under that statute whether or not they were acting under color of law. So it applies to private actors as well as government actors. But seemingly as a check on the overbroad application of the act to private persons, there is language in that law that says that people can be liable only if they interfere with what the state calls secured rights through threats, intimidation, or coercion. This is where things went sideways in Massachusetts. So although the drafters of the law may well have intended that piece to apply only to suits against private actors, it has been interpreted to also apply to suits against government officials. And so that means that in Massachusetts, you cannot win a lawsuit against a government official, a police officer, whoever else, for a violation of your rights based only on showing that your rights were violated. You have to show that the rights were violated through threats, intimidation, and coercion. This leads to some very absurd results. So for example, in Massachusetts, if a police officer says, "Stop that or I'll hit you," you can sue because the police officer has threatened, intimidated, or coerced you. But if the police officer just hits you, you cannot show threats, intimidation, or coercion. You will be told by courts that you cannot win a lawsuit for excessive force. Now again, obviously this is bad from the standpoint of people who get hurt by excessive force, but it is also bad for, the ultimate goal here is to keep these things from happening. And so it should not surprise you that with this law firmly in place, and this interpretation of this law firmly in place, in July 2020, the U.S. Department of Justice released a pattern of practice report about a police department in Massachusetts, the Springfield Police Department's Narcotics Bureau. This was the sole pattern of practice investigation by the Department of Justice during the presidency of Donald Trump. Pause and think to yourself for a moment how bad things have to be in the police department to be investigated by the Trump Department of Justice. Well, things turned out to have been pretty bad in Springfield. And what was the misconduct that the U.S. Department of Justice found? Hitting people in the head. The very thing, the very loophole that exists under the Civil Rights Act in Massachusetts. Do I know for a fact that that pattern of practice wouldn't have developed if the NMCRA had offered better remedies? Well, I don't know that for a fact. Do I know for a fact that the absence of the Mexico Civil Rights Act contributed to the pattern of practice report issued about the Albuquerque Police Department here in 2014? Well, I don't know that either. I don't think it helped. And so it's important to make sure that the New Mexico Civil Rights Act, which holds so much promise, which has brought all of you here, whether you're going to litigate on the plaintiff side or the defense side, but it's important to make sure that it is interpreted in a way that is consistent with its mission and purpose. Now, maybe you all, as I said, you all know more about the act than I do. You've read it. I confess I've also read it. And maybe you look at it and think, well, we didn't screw up the way that the folks in Massachusetts screw up, right? Our text is airtight. So you might be right about that, but as some of the murmurs that I just heard indicate, maybe you're not right. Or maybe the law has to be defended either way. And the federal law, Section 1983, is a cautionary tale in that regard. Does that text say anything about a qualified immunity defense? It does not. And yet courts have interpreted it to contain one. So the mere fact that the law exists and that it seems to cover a broad number of situations is not necessarily going to insulate the act from attempts to water it down. And that is why it is so great that you're here, because it seems to me that you're paying attention to this, and I would just ask you to continue to do that. Third thing. In my experiences doing civil rights, every advancement, every time, is quickly followed by arguments that the problem has been solved and there's no need to do anything else because of the good thing that just happened. So I mention this because I think inevitably the existence of the New Mexico Civil Rights Act is going to be cited as a reason why in New Mexico nothing else will need to be done. Those arguments will be made and they will be wrong. Again, I'm going to draw from my own experience in Massachusetts. So in 2020, the legislature there passed a bill on policing. Now, you should feel proud that it did not fix the Massachusetts Civil Rights Act, so New Mexico's ahead of the game still. But one thing that it did was it created a Police Officer Standards and Training Commission, or POST commission, which, among other things, is supposed to publish certain information about officer misconduct. That's great. Didn't exist before, terrific. Well, sure enough, 3 years later, in a case that's now pending before the state highest court in Massachusetts, a group of prosecutors wrote an amicus brief saying that they should not have to talk with police officers in criminal cases they're undertaking and ask those officers what misconduct they're engaged in, as they are required to do under Brady versus Maryland and Giglio against the United States, because the Post Commission will handle that now. So that argument's wrong. If you're a prosecutor and you have police officers on your prosecution team, you cannot ask somebody else to discharge your constitutional obligations for you. But it's this sort of thing that happens. And the truth is that in civil rights enforcement, we need a kind of belt and suspenders approach, because no tool is perfect. The New Mexico Civil Rights Act, for example, authorizes suits against the public bodies that authorize people to act under color of law, but not against the individuals, right? Not against the individual officers of government officials. And that's because, and every Civil Rights Act, every remedy is going to have trade-offs like that. Now, maybe by authorizing suits against public bodies, it will give the act will give those bodies the incentive to properly train their employees and the people who work on their behalf to avoid violating people's rights in the first place. But maybe the absence of a remedy against the individuals will at times mean that those individuals might need an extra measure of incentive from some other source to respect people's rights. There are trade-offs everywhere. And in fact, in my own practice, it's not like I've only done lawsuits under state or federal civil rights acts to try to vindicate people's rights. That would be weird, right? I've used other tools. In 2017, a case that my colleagues and I brought in response to a drug lab scandal in Massachusetts resulted in a decision overturning cases, drug convictions in 21,000 cases, which we think was the single largest dismissal of wrongful convictions in U.S. history. We didn't use the Civil Rights Act at all. It was the culmination of years of litigation building up state jurisprudence about people's rights. Not only is it kind of wrong to think that one tool can fix everything, it can yield the false belief that fixing problems is someone else's job. So we all know the story of Gideon against Wainwright, which the U.S. Supreme Court case that stands for the proposition that if the government's going to sentence you to incarceration and you don't have any money, the government has to supply you with a lawyer. Great. A lot of people know that. I assume you know that? You've heard that? Great, excellent. What fewer people know is that there is data indicating that after Gideon, the proportion of criminal cases brought against poor folks increased. So there's some data saying that around the time of Gideon, the indigency rate for state felony cases was around 43%. In the decades following Gideon, it rose to 80%. So criminal prosecutions became more focused, more targeted on poor folks in the wake of Gideon. So why is that? Well, I'm not sure. There's a scholar named Paul Butler who suggested some reasons, and one of them is that maybe once Gideon guaranteed lawyers to people, it made other folks involved in the criminal legal system feel like they had been let off the hook. If poor people get charged with crimes, they'll get lawyers, and it'll be the job of those folks and their lawyers to address the charges. Not my job to make sure I'm not bringing cases disproportionately against poor people. Now, I'm not sure if that's true, but I think that there is a real concern that when our legal system makes a new right available to people, and Gideon was the right to a lawyer, it may have the unintended consequence of making everyone else feel like they've been let off the hook. And now that the New Mexico Civil Rights Act has provided a new resource to the people of New Mexico whose rights have been violated, namely lawsuits, it's important to understand and guard against those same risks. If all goes well, the Act will help to remedy and even deter violations of people's rights. But those possibilities do not and should not let anyone else off the hook. The Act will not solve every problem, and its existence should not be leveraged into a reason to reject other solutions. It should not be said that because the people in New Mexico whose rights are violated can bring lawsuits, that remedying constitutional violations is their problem, or the problem of their lawyers. It's everyone's problem. So I'll just end with this, and then maybe we'll have time for questions. Civil rights lawsuits are enormously important. And this group, this act is amazing. I'm hopeful that it can provide some means to deter wrongful conduct and to develop state constitutional law in New Mexico so that these violations don't happen in the first place. But civil rights lawsuits, even valid civil rights lawsuits, are a sign that something bad has happened. Something already has to have gone wrong for someone to have a case that's worth bringing or worth winning. And so that's why I think it's important to remember that the goal of any act like this is not to create lawsuits, it's to create justice. I will just end with one thing. You know, Julie and I have been, we opened the doors of this new state Supreme Court initiative, the ACLU, in May, and we've been talking to people all over the country. And one of the things that we think is our job is to spread good ideas. And I came into this thinking, well, I'm going to tell people about the New Mexico Civil Rights Act, because I know, actually, I'm on an email chain right now with a lawyer in another state who's working on creating a Civil Rights Act in their state. And I was like, you got to check out what they did in New Mexico. So I came into this symposium expecting that. What I think I did not expect was the sheer number of people who would be here. More accurately, the sheer number of people that Chanel Daniels brought here. And so I think that piece of it is important too. You know, we've had a debate about civil rights in this country, and particularly the last few years, a debate about police violence. And in some places, they didn't pass the Civil Rights Act. And in some places, they're not talking about it anymore. And so what is so impressive to me about this is that not only do you have this great new law, but that there's clearly interest in getting it right. And so I think that's what I want to tell people in other states, not just about the existence of this act, but that the existence of people who are going to stay on top of it. And I think we have a couple minutes for questions.
Hello, thank you guys for being here. My name is NMCRA. My family is de Peñasco, Nuevo Mexico, about, I think, a 2-hour drive north, specifically in Rio de San Juan. As you both mentioned, New Mexico's constitution is very unique in addressing the fact that there were people here before the Americans conquered it, specifically Nuevo Mexicanos, or as it's colloquially known in the Constitution, Spanish American, Spanish-speaking people. Within the Constitution, there's some clauses about rights guaranteed under the Treaty of Guadalupe Hidalgo, equal access to education, no discrimination, in jury, voting, voting caucus, and whatnot. I was put on the state constitutional rights with Chief Judge Sutton's book at the University of Georgia, and I was connected with retired Chief Judge Banzi, wherever she's at, and reading some of her opinions, interpreting some of these things. As a future young practitioner, I wanted to do state common law and civil rights stuff in northern New Mexico. And like you referenced, it's not like these things have been litigated in the past a lot. What recommendations do y'all have for the novelty of these specific clauses because of New Mexico's unique history in young practitioners and practitioners generally litigating these types of cases that don't have federal or other state analogs?
It's a great question. I mean, first of all, one nice thing about the Act is that it doesn't draw distinctions among the different aspects of the Bill of Rights, right? It says you can bring lawsuits for violations of rights contained in the Bill of Rights in the Mexican Constitution, and the things that you're mentioning are there, and they get as much billing, as much importance to any right. So I would say to start with the fact that the mere fact that there may not be case law doesn't mean that anything is less viable. It means you just have to sort it out. And you know, we've seen some other cases. There's one pending in the Supreme Court of Maine right now. It's on the right to food, and and that's someone who's saying that the right to food means that the laws prohibiting Sunday hunting in Maine are unconstitutional. Like, are they going to win that case? I don't know. But the case will result in some clarity about what that right means. And so I don't have a great answer for you other than like, try stuff. Yeah, I'm Art Leonard. I'm one of the authors of the law review issue that's coming out. One of the problems that we have in New Mexico, which really follows up on our previous gentleman's question, is we were one of the last states in the union to be allowed to be a state. And part of that, I think a big part of that reason is summed up in one word, which is racism. Because we have a lot of Spanish speakers and indigenous people who are not considered competent to have a state government or write a state constitution, and that today in a tendency to have what I would call a monkey see, monkey do theory of state constitutional interpretation, the lockstep approach, and just saying, well, we came along late, so we just copied and pasted our state constitution from what other states did, and so we should just mindlessly look elsewhere. And so my question to you is what's your response to that as far as why do we need outside experts? When should I call you at the national office of the ACLU? Why can't we just figure things out ourselves? Why shouldn't I just go to this gentleman who just asked the previous question and ask him instead of ask you?
Yeah, so I think, am I echoing weird? Come over here. So I think it's a really interesting question, and I do think part of the challenge, but also opportunity in state courts is that, you know, in a lot of states, it is an open question. How do you interpret your constitution? Do you just, should I come up there? You know, I think in a lot of states it's an open question how you interpret your constitution. Utah, for example, right now has cases underway where they're actively briefing, when do you look to an originalist analysis? And if you do, what time period do you look at? So I think a lot of this is going to be state specific. And also I think, you know, one of the things in part to your question, I think people should read their own constitutions and read their own decisions before you look anywhere else, not just federal law, but to sister states. I do think that one of the ways, though, especially where there's an absence of case law, you can start with the text, let the text be the guide, but that can only get you so far sometimes with certain provisions. And so, you know, I think one thing that is helpful in looking across states and that can be really beneficial is to see where did this provision in our Constitution come from? How was it understood at the time that we adopted it and pulled it from another state, if that's what happened? And, you know, there are a lot of briefs that have delved into the history of some of these provisions, which, as I said, a lot of the state constitutional provisions look much more like each other than the federal Constitution. And so, you know, that doesn't mean that the New Mexico courts have to accept that. But I think looking to other state laws, or at least having available what this means in another state, is at least one helpful indicator, and I would say is probably more helpful than, in some circumstances, federal precedent, or just saying let the text be the guide, which is helpful, but it's not going to answer all of the sort of hard applications that come up.
Okay, thank you for those wonderful questions, and thank you, Julie and Matt, for being here and imparting your wisdom with all of us.